is an article written by Audu Bulama Bukarti on the recent suspension of the Chief Justice of Nigeria, Walter Onnoghen, made available to PoliticsNGR. Read below. Given the supersonic speed at which the CCB, I am also concerned with the time of the whole thing. But this is just a marginal note, a statement by the wayside. I will keep it for another day. Now, turning to the topic at hand, I do not see anything wrong or illegal with the suspension of the CJN and swearing in yesterday of Hon. Justice Ibrahim Tanko. The action of PMB is constitutional. Nay, he had a duty to act in the way he did. Here are my 7 reasons. 1. PMB did not act on his own motion. He acted on an order of the CCT. 2. The CCT has an inherent power under Section 6 of the Constitution to issue any order that will promote the rule of law and ensure the smooth conduct of its proceedings. I believe this order does both. See point 7 below. 3. Some lawyers have argued that CCT's order is illegal or even unconstitutional. But this is not PMB's business. He can't question the legality of a judicial decision, as doing so will tantamount to the president sitting on appeal on the judgment of a court. 4. Under our constitutional system, PMB has no option than to obey the said order. That is why we have been urging him to obey the orders on Dasuki and Zakzaki. I repeat the same call here today. 5. The provisions of Section 292 cited by the NBA and others do not apply to this matter, as the CJN was not removed. He was suspended, pursuant to a valid and subsisting order. The removal envisaged by and under Section 292 of the Constitution means the dismissal of someone from a job, while suspension, as in the present case, means to temporarily prevent from continuing or being in force or effect. 6. The CJN is the head of the all Nigerian courts and judiciary, as well as the chairman of the National Judicial Council, which, under his chairmanship, exercises supervisory and disciplinary role on all judges and judicial officers in Nigeria. This means any decision reached by CCT may likely go on appeal up to the Supreme Court, where the CJN is at the helm of affairs. 7. It is against the rule of natural justice for Justice Onnoghen to remain the CJN and chairman NJC while facing trial under the same judges whose promotions, disciplinary and other related matters are under him. 8. I believe this action will facilitate quick dispensation of justice in this matter. Before the order, the generous Sands, representing the poor, CJN had started taking steps that are clearly intended to frustrate his trial. They had started raising frivolous issues and making empty applications because they knew that their client had an upper hand. Now that he has been suspended, the defense counsel will be serious to prosecute the matter to its conclusion so that their client might be reinstated as quickly as possible if he is not found guilty. 9. Assuming, without conceding, that there are any anomalies in the procedure adopted, I would rather forego any such anomalies for the crushingly disappointing alleged acts of the person who is supposed to hold those who violate our laws to account. I feel we must get the bottom of the allegations against